judges of the High Court of the State. In the great investigation. The Honorable Justice Daniel E. He moves around campus. He comes in here. And what's it? Sometimes you wonder when immediately he's done, say, returns back immediately to his music. Also, senior advocate. The rest of the registrar is here. The way on official assignment.
Chancellor, that is Mr. Harrison Osai. Senior Deputy Registrar, representing the Registrar of the University of Benin, Mr. Ademola Bobola. Please, another round of applause again. Shortly, we are going to introduce, my lords, the judges of the High Court of Edo State. We're happy to have all of them here. It's a privilege. So, for our students, well, you are seated behind, but if you can stretch your neck, you have the judges who occupy the Temple of Justice in Edo State seated right in front of you. So if you don't mind, the judiciary in Edo State is here with us in the Akindeko Auditorium of the University of Benin. This is a memorable day indeed. We are going to mark this date on our diary. Okay, thank you. The chief host is the Vice Chancellor. We already have him seated. But we have the host of today's event. He's been very busy and he's been walking around. He's also very energetic. We're talking of the Dean of the Faculty of Law. He is Professor Bright Bazwai. Oh, he's up here already. Dean, sir, you're going to be seated with my Lord the CJ. You're welcome, sir. Permit me to acknowledge my lords, the judges of the High Court of Edo State. Please, as students, you are going to acknowledge my lords as I mention their names. All right? And you know how we do it at the Faculty of Law. We already have the Chief Judge of Edo State with us, but I'm going to mention his name again. So, on the top of the list is Honorable Justice Daniel Iyubusa Okumbowa, Chief Judge of Edo State. Following is Honorable Justice Efe Iponwoba. You're welcome, Mom. We have with us Honorable Justice A.N. Era Courage Ugbebo. Welcome, my Lord. Courage Ugbebo. Welcome, my Lord. We have here with us Honorable Justice M.N. Asemota. Welcome, my Lord. Then we have here with us Honorable Justice P.A. Akinhero. Welcome, my Lord. Also with us is Honorable Justice, we have Honorable Justice Ohimai Obiagele. Welcome, my Lord. We have with us Honorable Justice V.O. Eboreme. We have with us Honorable Justice V.O. Eboreme. My Lord, you're welcome. We have here Honorable Justice N.A. Imokwede. You're welcome, my Lord. We have with us Honorable Justice V.O.A. Obiawe. My Lord, you are welcome. Also with us is Honorable Justice A.T. Momodu. My Lord, you are welcome. Also here is Honorable Justice W.I. Azigbemi. My Lord, you are welcome. We have Honorable Justice Esohe Bazwaye. You're welcome, my Lord. We have Honorable Justice R.A. Ugbevoin. Welcome, my Lord. Also here is Honorable Justice Etiosa Adekambi. Welcome, my Lord. We have with us Honorable Justice M.E. Itsweli. Welcome, my Lord. With us is Honorable Justice H.O. Garuba. Here with us is Honorable Justice T.I. Ege Abe. Welcome, my Lord. So with us is Honorable Justice I.A. Dika. Welcome, my Lord. We have with us Honorable Justice B.E. Oniha. You're welcome, my Lord. We have with us Honorable Justice O.A. Otamiri. Okay. I have here Honorable Justice O.M. Obayuwana. My Lord, you are welcome. We have with us Honorable Justice E.A. Oko. You're welcome, my Lord. We have here Honorable Justice Maureen Omori Ojo. You're welcome, my Lord. Also with us is Honorable Justice J. Okundamia. You're welcome, my Lord. We have here the Chief Registrar of the judiciary. You are going to applaud him specially, and I will tell you why. But my Lord, the CJ, please, you permit me to say this. And Vice Chancellor, sir, you also permit me to say this, that the Chief Registrar of the Edo State Judiciary was the one who conducted my wedding. He joined me and my wife. So, he is Mr. Benson Osawaro. You're welcome, sir. The marriage is still standing. Thank you, sir. We have with us the senior advocates of Nigeria. Please join me in welcoming a distinguished senior advocate of Nigeria and a former Attorney General of Edo State. Very tall, telling you his height in the legal profession. He is Mr. O.A. Omonua, S.A.M. You're welcome, sir. Our student would like to know you. Please applaud him. Students. You're welcome, sir. We also have with us a distinguished legal practitioner. He is Mr. K.O. Obamoge, S.A.N. You're welcome, sir. You're welcome, sir. We're going to take more recognitions. Students, your professors are here. I will call their names and you will acknowledge your professors as we proceed with the program. Right now, we're going to take the welcome address of the chairman, who is also the chief host, and that is the Vice Chancellor of the University of Benin, Professor Edoba B. Omoige, S.A.N. A round of applause, please, for the Vice Chancellor.
The judiciary. It is a constitutional safeguard for society. Without an independent judiciary, democratic institutions lose credibility, rights lose meaning, and the Constitution loses its vitality. Nigeria's democratic experience underscores the central role of the courts in preserving constitutional order. At critical moments in our national life, the judiciary has been called upon to act as the stabilizing force against arbitrariness and abuse of power. Yet, this role is neither easy nor cost-free. It demands courage, institutional support, and an enlightened public understanding of the judiciary's constitutional mandate. Defense of judicial independence cannot be left to judges alone. It requires the active engagement of the bar, the academia, civil society, and the wider public. It is in view of the above statement that universities, in particular, are expected to nurture a legal culture that respects constitutionalism, reasoned education, and the ethical standards of the legal profession. It is not a mean feat to have this remarkable lecture delivered today by our own Chief Judge of Edo State, the Honorable Justice Daniel Yobosa Kumboa, a distinguished jurist whose career exemplifies judicial discipline, institutional loyalty, and respect for the rule of law. Memorial lecture serves as a powerful reminder that the law is not simply a set of rules, but a principled enterprise grounded in justice, restraint, and public responsibility. Legacy of Justice Anthony Chukwuemeka Idigbe challenges all professionals in law to approach the study and practice of law with integrity, intellectual rigor, and moral courage. Distinguished ladies and gentlemen, as we mark the 20th edition of the Justice Anthony Idigbe Memorial Lecture, Chukwuemeka reaffirms challenges all professionals in law to the ideas that study and practice of law with integrity, judicial independence, intellectual rigor, and moral courage, and the unwavering fidelity to the rule of law. As we mark the 20th edition of the Justice and students of the Faculty of Idigbe Memorial Lecture, remembering him, reaffirms challenges collective commitment that judicial office above all, that study and practice of law, held on behalf of integrity, judicial independence, intellectual rigor, and moral courage, and commend the fidelity to the rule of law. Dedication to mark the 20th edition of the Justice and students of the Faculty of Idigbe Memorial Lecture. It's now my pleasure remembering him, reaffirms challenges collective commitment that judicial office declared that study and practice of law, held on behalf of integrity, judicial independence, intellectual rigor, to provide all moral courage thoughtfully, and commend the fidelity to the rule of law. Dedication. Thank you for listening.
Another round of applause for the Vice Chancellor, Professor Edoba B. Omoege, SAN. Thank you very much, Vice Chancellor, sir, and Chairman of today's 20th Idigbe Memorial Lecture. Vice Chancellor has reaffirmed his commitment to judicial independence, which the late Justice Idigbe stood for. We're going to take the welcome address of the host, that is the Dean of the Faculty of Law, Professor Bright Bazwaye. Please welcome him. Thank you, sir.
I think it will be safe for me to stand on the protocol that has been ably established by the Master of Ceremony and also my Vice Chancellor. But I must not fail to mention the Chief Judge of Edo State, the judges of the State High Court, and my Vice Chancellor. Let me stand on the other established protocol so far. My distinguished colleagues, a Leonard 6, please. That is why it was safe for me to stand on the protocol so that I don't commit harakiri. Leonard 6, thank you. Thank you, sir. On behalf of the Faculty of Law, University of Benin, it is my honor to welcome you to the 20th Justice Idigbe Memorial Lecture, a program that has become a defining feature of our faculty's intellectual and professional engagement with the Nigerian legal system. This lecture series occupies a unique place in our academic tradition. It is both a memorial and a mandate. A memorial to Honorable Justice Chukwuemeka Idigbe, JSC, and a mandate to interrogate with seriousness and candor the principles that sustain constitutional democracy and the administration of justice. Justice Idigbe exemplified the highest ideals of judicial office. His career reminds us that judicial authority derives its legitimacy not from force or favor, but from independence of mind, fidelity to the Constitution, and disciplined adherence to the rule of law. For the Faculty of Law, his life represents the convergence of legal scholarship, judicial craftsmanship, and professional ethics. As legal educators, we are particularly conscious that the defense of judicial independence begins long before appointment to the bench. It begins in the classroom, in the cultivation of legal reasoning, professional responsibility, and respect for institutional boundaries. The values Justice Idigbe embodied must therefore remain central to our curriculum and to our understanding of what it means to train future lawyers and judges. We are especially honored that this year's lecture will be delivered by the Chief Judge of Edo State, Honorable Justice Daniel Iyobosa Okungbowa. My Lord, we are grateful for your presence and for your willingness to share your insights with us. The theme of today's lecture, Judicial Independence, Democracy, and the Rule of Law in Nigeria, speaks directly to the contemporary challenges facing our legal system. Judicial independence is not merely an ideal, it is a professional culture that must be nurtured and defended. Without it, constitutional guarantees lose substance and the administration of justice becomes vulnerable to external influence. For the Faculty of Law of the University of Benin, this lecture serves as a bridge between theory and practice. It provides our students with the opportunity to engage directly with lived judicial experience and to appreciate that the law is not only an academic discipline, but a public trust. To our students, I urge you to listen, not only for doctrine, but for values. The legal profession demands intellectual excellence, but it demands even more integrity, restraint, and courage. The life and work of Justice Idigbe stand as lasting reminders of these obligations. Distinguished ladies and gentlemen, as we mark the 20th Justice Idigbe Memorial Lecture, we reaffirm the Faculty of Law of the University of Benin's commitment to advancing legal education that promotes constitutionalism, judicial independence, and professional honor. I once again welcome you all and wish us a most enlightening lecture. Thank you.
That was the Dean of the Faculty of Law, Professor Bright Bazwai. Another round of applause for him, please. Before I go on, I would like to know if the representative of the Idigbe family is here. Please, if the rep of the Idigbe family is here, would like to know you and bring you upstage. Okay, thank you. All right, soon, oh, thank you. We are going to take the citation of the Chief Judge. But before we do that, my Lord, before we do that, we are going to do two things. First, to know about Justice Chukwuwike Idigbe. I mean, very many times we just hear of the Idigbe Memorial Lecture. Why are we honoring him? Who was this man? So we'll just have a brief about him, about Justice Idigbe. I'll read from here in 3 minutes. Just a brief about Justice Idigbe. The Honorable Justice Chief Chukwuwike Idigbe, OFRCON, the Izoma of Asaba, was born on the 12th day of August 1923 at Kaduna in the present Kaduna State to Chief Ignatius A.O. Idigbe and Mrs. Christiana M. Idigbe, both deceased and devout Christians of the Catholic faith. His father, Chief Ignatius Idigbe, from the Umuadajo family of Umuaji quarter in Asaba, Delta State, is one of the 2 children of Obi Idigbe, the titled grandfather of Justice Idigbe by his grandmother, Mrs. Ponoka Idigbe. Mrs. Christiana Idigbe is from the Okonwize family of Umueze quarters in Asaba. Education. Justice Chukwuemeka Idigbe started his education at St. Mary's Catholic School, Port Harcourt, between 1928 and 1936. In 1937, he proceeded to the popular and prestigious Christ the King College, CKC Onitsha, for his secondary education, which he concluded in 1940. From 1943 to 1946, his lordship was at the King's College, University of London, where he obtained an LLB London, second class upper division, and carted away the Campbell Foster Prize in Criminal Law and Procedure in 1946. Within the same period, he enrolled at the Middle Temple Inns of Court, London, and was called to the bar in January 1947. His professional career. On the return of his lordship in 1947, he was received by the people of Asaba with 100 gun salutes. And yes, please applaud him. I mean, it was a feat. And several days of feasting. He soon settled to private practice, legal practice in Warri, Delta State. His practice, however, covered most of the former Western and Eastern regions. And at the time of the Western African Court of Appeal, he frequently went to Accra to argue cases. And when the Federal Supreme Court was created, he made numerous appearances there. The Waka and Federal Supreme Court law reports are a testimony to this fact. In fact, it was once said that after his lordship appeared before the then Dufus J at the Ikeja High Court and had just left the court, the Honorable Justice Dufus could not hold his loud remark to the hearing of the lawyers in court that there goes the best lawyer in Western region. The lawyers in court on that occasion still attest to this event. In recognition of his hard work and dedication, as was customary in those days, Justice Chukwuemeka Idigbe was appointed a High Court judge on the 22nd of May 1961 after 14 years of successful private practice. As he often recalled, such an appointment in those days was an honor which he could not refuse, though it meant abandoning an otherwise lucrative private practice. Just 3 years after, he was elevated to the Supreme Court on the 10th of April. Yes, I'll say that again. Just 3 years after, he was elevated to the Supreme Court on the 10th of April 1964, and as was the practice then in March 1966, he was seconded to the then Midwestern region as the Chief Justice. However, with the Civil War in 1967, his lordship ceased to be a judge as he was caught on the other side, that is Biafra. Upon the cessation of hostilities in 1970, Justice Chukwuemeka Idigbe was unemployed and was not given back his judgeship. He had to sell most of the property he acquired in Warri during his private practice in order to train his numerous brothers, sisters, children, and other relatives. However, in 1972, he secured a partnership in a firm of legal practitioners, Ivan and Bernard and Co., a position he held until 1975 when he was reappointed a judge of the Supreme Court of Nigeria. The immediate family was, of course, opposed to his accepting the appointment, considering his past experience and the lack of financial inducement in government employment. Of this, he said, I quote, "If I am being reappointed at a time when other people are being retired, retrenched, or dismissed, then it is a recognition of my worth by the government, an honor which I cannot refuse for any financial or other consideration." End of quote. Soon after his re-emergence in the Supreme Court, Justice Idigbe was appointed the chairman of the Land Use Committee, set up to review the land tenure system in Nigeria and made recommendations. The work of that committee led to the promulgation of the Land Use Act of 1978, which, yes, please a round of applause. Which made sweeping changes in the land tenure system of the country that is presently incorporated as part of the 1999 Constitution of the Federal Republic of Nigeria. The Guardian editorial of September 17, 1983, entitled Homage to a Fine Jurist, sums up the performance of his lordship on the bench. It says, among other things, quote, Justice Idigbe's death is an irreparable loss for reasons of his unique example. For instance, his enormous contributions at the Supreme Court to the development of our law are indisputable. An erudite and principled judge who delighted in legal arguments, the late judge wrote in his 10 years in the court some of the most lucid and tidy judgments to be found in the book. It is perhaps not an accident, as records of our law report will show, that the judgment he wrote both as a High Court judge and also at the Supreme Court are some of the most frequently cited by lawyers. Even his own peers at the highest court of the land deferred to him and acknowledged his quickness of perception. And when Mr. Rotimi Williams, SAN, spoke of Idigbe's unrivaled capacity to get quickly to the heart of the matter or matters in debates, he spoke for many at the bar who were endeared to this brilliant jurist. End of quotes. That is the man that the Faculty of Law, University of Benin, has chosen to honor with lectures annually to teach the younger generations that money or no money, it pays to hold on to what is right. Integrity itself is a currency. Hold on to it. We've been doing this for many years. This is the 20th in the series. And today, we have with us the distinguished Chief Judge of Edo State, Honorable Justice Daniel Iyobosa Okumbowa, to tell us about judicial independence. Before we take the citation of the Honorable CJ, that will be done by Professor Osaitin Aibobo. I'm sure he's set. I will call him up shortly. I would like to recognize one of our own. The students will not pardon me if I don't recognize my Lord, the Honorable Justice Edogogo Eboigbe. Aha, thank you. So you won't question me, okay? All right. We also have with us the Secretary to the Judicial Service Commission, Mr. Michael Osigbeme. You're welcome, sir. And we have a worthy alumnus who will always attend our programs. Please permit me to recognize Honorable Charity Igodala Aigobariega, the Minority Leader at Edo State House of Assembly. You're welcome, sir. You're welcome. So at this time, we are going to take the citation of the Chief Judge of Edo State, the Honorable Justice Daniel Iyobosa Okumbowa. Professor Osaitin Aibobo, please. You're welcome, sir.
Vice Chancellor, sir, Professor Edoba Morige, the Chief Host, my Lord, the Chief Judge of Edo State, Justice Daniel Yobosa, Okungbowa. Judges of the High Court of Edo State present, learning 6, fellow professors in the Faculty of Law, my colleagues, invited guests, and our dear students. You are welcome to this lecture. It's my pleasure to read the citation of the Chief Judge of Edo State, Hon. Justice Daniel Yobosa Okungbowa, our lecturer today. Hon. Justice Daniel Yobosa Okungbowa was born on the 27th day of April 1961 to the family of Honorable Justice G.O.U. Okungbowa of blessed memory and Mrs. Christiana Olubisi Okungbowa. He hails from Idigbe in the Hunde local government area of Edo State. His Lordship's educational journey is long and rich and traverses continents. It began in Benin City, where he attended a Motam preparatory private school from 1966 to 1972. Our Lady of Fatima College, Auchi, from 1973 to 1977, and Edo College from 1977 to 1979. Thereafter, he proceeded to the prestigious University of Lagos from 1979 to 1983, where he earned his first degree in law. The Nigerian Law School in Lagos from 1983 to 1984 for his professional training as a legal practitioner. This journey also took him outside the shores of Nigeria as he attended the University of London in 1991 for a short program. His quest for knowledge did not stop there. After his return from the UK, he returned to the classroom again, but this time at the Nigerian Institute of Advanced Legal Studies in 1996. During this educational journey, his Lordship bagged a number of degrees and certifications, including the ordinary level school certificate, the higher school certificate, and, sorry, there's a mix-up there. There's a mix-up there, sorry. He also obtained several certificates, including certificate in legislative drafting, certificate in negotiating international contracts, sovereign borrowing arrangements, and international arbitration. He is also a fellow of the Chartered Institute of Arbitrators, 2015, and a fellow of the Chartered Institute of Mediators and Conciliators, 2020. Honorable Justice Okungbowa's professional journey began in 1984 when he worked as legal advisor and company secretary to the Central Investment Company, Enugu, in 1985. He became a law officer with Debo Akande and Okonjo Solicitors, Benin City. The next year, that is 1986, he moved to Lagos and worked again as a law officer in Yinka Doherty and Company in 1987. He joined the services of the Ministry of Justice, Benin City, in 1987, where he served for 10 years, up until 1997. In that year, he left the Ministry of Justice and for the first time ventured into private legal practice on his own, a journey that culminated in 2001 when he was appointed a judge of the High Court of Edo State. On the bench, his Lordship consistently demonstrated a very strong knowledge of the law, impartiality, fairness, excellent decision-making skills, high integrity, and high ethical standards, as well as ability and courage to manage complex cases. It is no wonder that he was later appointed to wear the mantle of piloting the affairs of the Edo State Judiciary as the Chief Judge of Edo State, High Court of Justice, Benin City. This is a round of applause for that. A position he occupies till date. Those who are acquainted with him know that his Lordship, both in his official and personal capacity, notices that he observes a simple lifestyle, he is modest, and is humble. His Lordship has served in various ad hoc roles He was counsel to Justice V.O. Omange Judicial Commission of Inquiry into the utilization of disbursement of special grants to local government councils for the payment of arrears to primary school teachers, 2004. Chairman, Law Officers Association of Nigeria, Edo State Branch, 1991 to 1997. Legal Advisor, Association of Senior Civil Servants of Nigeria, Edo State Branch, 1992 to 1997. National Secretary, Our Lady of Fatima Old Boys Association, 2000 to 2001. Member, Governorship and Legislative Houses Election Tribunal, Ondo State, 2007 to 2008. Chairman, New High Court Civil Procedural Rules Draft Committee, 2010. Member, Governorship and Legislative Houses Election Tribunal, Osun State, 2010. Chairman, Edo State Local Government Election Tribunal, 2013. Chairman, High Court Civil Procedural Rules Draft Committee, 2018. Honorable Justice Daniel Yobosa Okungbowa is a recipient of several awards and honors. Amongst these are Certificate of Honor as a Benin Achiever by Omonoba Erediawa, Oba of Benin. A round of applause for that. Presidential Award of Commitment to the University of Lagos Law Class of 1980-83, Reunion, 2013 and 2014. Certificate of Honor from St. Joseph Catholic Church, Merit Award for Unquantifiable Contribution to the Development of Our Laws and the Legal Profession by the Nigerian Bar Association, the Lion Bar, Benin Branch, 2020. He is patron of several church bodies, including Family Society of the Catholic Archdiocese of Benin City, Pages of the Blessed Sacrament, Protocol Ministers, and others. His Lordship has attended several courses and conferences, including those organized by the National Judicial Institute, the Chartered Institute of Bankers of Nigeria, and the Nigerian Deposit Insurance Corporation of Nigeria. He has presented papers at the Law Weeks of the Nigerian Bar Association, Benin, Uromi, and Ekpoma branches, Law Officers Association of Nigeria, Benin branch, and faculties of law of some Nigerian universities. His hobbies are playing golf, farming, looking at his Lordship, you will know he's a farmer, and listening to music. His Lordship is happily married with children. Ladies and gentlemen, I present to you the Honorable Justice Daniel Yobosa Okungbowa. Thank you, my Lord.
Thank you very much. Let me start by adopting the order of protocol ably established by the Master of Ceremonies. But permit me to specially recognize my brother, the Vice Chancellor of this great institution, Professor Edoba Omorege. My other brother and classmate, O.A. Omonua, SAN, OFRO. My learned brothers, of course, thank you for coming here in large numbers. Thank you for the support. I want to also recognize my sons, Dr. Okungbowa and Okungbowa, a lawyer in equity. Thank you for coming. From this great institution as well, from this faculty. I'm greatly honored to have been asked to deliver this year's annual Honorable Justice Idigbe Memorial Lecture. It is indeed humbling to be counted among the enviable array of erudite speakers comprising the creme de la creme of society and the legal profession who have graced this stage for this purpose in the past. In doing so, I begin by expressing profound appreciation, felicitation, and congratulations to the Vice Chancellor of this great citadel of learning, Professor Odoba B. Omorege, SAN, the Dean, Faculty of Law, University of Benin, Professor Bright Bazoye, and all staff and students of the faculty who have collectively maintained this high standard and tradition of lectures in honor of one of the greatest of the Nigerian judiciary and jurist par excellence in our legal ecosystem, Honorable Justice Chukwuike Idigbe, GSC of blessed memory. What a privilege for me to add my voice today to the celebration of this great legal icon. By way of introduction, our topic for today's discourse is judicial independence, democracy, and the rule of law in Nigeria. It is gratifying to be offered an august forum like this to speak on this very topical and all-important issue. Undoubtedly, it is one to institutionalize the rule of law and democratic ethos in the odious task or collective task of nation building in our dear state and country, Nigeria. It was Baron de Montesquieu that once wrote in his popular book, Spirit of the Laws, that, quote, when the legislative and executive powers are united in the same body, there can be no liberty, because apprehension may arise, lest the same monarch or senate issue enact tyrannical laws to execute them in tyrannical manner. Again, there's no liberty if the judicial power be not separate from the legislative and executive. Were it joined to the legislative, the life and liberty of the subjects will be exposed to arbitrary control, for the judge would then be the legislator. Were it joined to the executive power, the judge might behave with violence and oppression, end of quote. The above quote aptly underlines the imperativeness of independence of the judiciary in democratic nation building. From about the time of Montesquieu's political philosophies, sorry, I take that again, I was distracted. From about the time of Montesquieu's political philosophers have extolled the virtues of separation of powers and its necessary corollary, which is the principle of the independence of the judiciary. They have argued, and rightly so, that three arms or three organs of state should be independent of one another so as to provide checks and balances among them and avoid the danger which arises from the concentration of powers in the hands of one man or a group of men. In this way, arbitrary rule is precluded, the rule of law entrenched, and democracy with its attendant guarantee of respect for the fundamental rights of the citizen is assured and protected. In another related instance, the late sage Chief Obafemi Awolowo, in his book, quote, Thoughts on Nigerian Constitution, passionately asserted that the principle of separation of powers is not just an abstract doctrine or an academic legalistic formula. In practical politics, it is a most potent means to the outlawry of tyranny and the enthronement of democracy. What is immediately clear from the above roadmaps is that judicial independence is the bedrock of any democratic society and the linchpin of the rule of law. It assures citizens that justice will be dispensed fairly, impartially, and without fear or favor, regardless of the litigant's status or government's interest. In addition, it is also one which the entire Nigerian judiciary guides jealously in everyday dispensation of justice. According to the National Judicial Policy, issued by the National Judicial Council, NJC, the independence of a judge is sacrosanct and very necessary to impartial justice delivery. All institutions must therefore respect, protect, and defend that independence. In this paper, we shall examine the nature and application of this hallowed principle to the Nigerian situation, especially against the backdrop of existing national and international legal framework. In doing so, the interconnectivity between judicial independence and the sanctity of the rule of law in Nigeria will be considered. The paper also briefly highlights, through the prism of some decided cases, some notable areas that our judiciary has courageously upheld and promoted our democracy, while also bringing to the front burner some real and present challenges to the independence of the judiciary in this country. Conceptual definitions. First is judicial independence. According to Black's Law Dictionary, to be independent means not subject to the control or influence of another, not dependent or contingent on something else. Judicial independence basically means that judges are at liberty to adjudicate on cases based on the evidence, facts, and circumstances presented before them by disputing litigants and the law without improper internal or external influence or interference from other branches of government, executive or legislature, political parties, private interest, public opinions, or even the media, inclusive of social media, etc. In relation to the latter, unchecked and unregulated social media trials and commentaries that are freely conducted daily in a digital space by content creators and people who have little or no knowledge of the actual facts or legal training. During such social media unfair trials/wanton commentaries, rather than the content of the twin scale of justice being heavy with evidence, what we often find is a heavy dose of concocted and exaggerated facts and conclusions, which in many cases are misconstrued, defamatory, and in complete disregard of the provisions of the Cyber Crimes Act 2015. I shall return to this issue shortly. Suffice for now for me to say that the concept of judicial independence encompasses two main aspects. These are institutional independence and judges' independence. Let us briefly look at these two elements. A, institutional independence. Institutional independence entails that the judiciary, as an arm of government, must be independent from the executive and legislative branches in its funding, administration, and appointment processes. In most known democracies, the judiciary is always accorded the freedom to conduct its affairs without fear of interference, intimidation, threat, ill will from any other arm of government. It is in order to ensure that this is done that the National Judicial Council was established under the 1999 Constitution to conduct the affairs of the judiciary within the provisions of paragraph 21B, part 1 of the third schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. In the exercise of its constitutional powers, therefore, the Nigerian judiciary is entrusted with the constitutional mandate to independently look into and determine, quote, all matters between persons or between government or authority and to any person in Nigeria and to all actions and proceedings relating thereto for the determination of any question as to the civil rights and obligations of that person. In the day-to-day exercise of these functions, a strong and independent judiciary may from time to time give judgment for or against all shreds of litigants, inclusive of other arms of government. Unfortunately, what we find nowadays is that whenever judgments are given by the judiciary in favor of government, some people unwittingly accuse the judiciary of corruption and having become an appendage of the government of the day or other arms of government, especially the executive. But whenever judgments go against the government of the day, those same people fall meaningfully and ominously silent. Rather, at such times, it is the turn of the other side to cast aspersions on the judiciary and accuse it of being corrupt or anti-government. Here lies the lot of the Nigerian judiciary. But the truth is that we, as we administer justice to all manner of persons, judges are not moved by these unfortunate sentiments and characterization in our avowed role of acting as a check on other arms of government in order to bring the much desired balance to the pillars of our democratic system of government in line with the principle of separation of powers / checks and balances. In doing so, we are unapologetic. Independence of individual judge. Under this head, individual judges in the day-to-day adjudication of cases are free from external pressure in their decision-making from external influences of any guise. Generally, a judge must be independent from all forms of improper pressure. This is what is referred to as decisional independence in paragraph 7.4 of the National Judicial Policy of the NJC 2016. Therefore, in deciding cases, every judge, being subject only to the law, must do so in accordance with his judicial oath, which dictates that he should discharge his duties and perform his functions honestly, to the best of his ability, and faithfully in accordance with the Constitution and the law, and without allowing his personal interest to influence his official conduct or his official decisions. It is the independent judge, loyal only to the rule of law, that can protect our constitutional liberties, ensure fairness, and who, on sentry duty, stands guard against the excesses of those in power. In doing their jobs, judges must be allowed to adjudicate freely. The principle of judicial independence is gravely damaged if judges were subject to reprimand on the basis of errors made in their judgments by supervisory authorities. Therefore, in ordinary circumstances, unless in cases of obvious proven mischief or bad faith, judges should not have to fear punishment in the event that their rulings are later determined to be mistaken or wrong. That is why our appellate courts are there. Law. Since the era of Professor A.V. Dicey, he and several other scholars have defined, nourished, and contributed to the growth of the principles of the rule of law. In Omasheye against the Federal Republic of Nigeria, Judge Will, JCA, posed the question, what is the concept of the rule of law in a democratic society such as Nigeria? In answering this question, His Lordship stated as follows, and I quote, "Rule of law is a concept that has been with the world for over 25 centuries, when it was first propounded by the great philosopher and thinker Aristotle. However, in modern contemporary jurisprudence, it is described as the condition in which all members of the society, including the rulers and the led, accept the authority of the law. Under it, no man or woman is liable to be punished except for a breach or infraction of the law committed and established before the courts. It is a concept in which the citizen is entitled to the observance of the principles of natural justice in the determination of any question involving his rights and obligations under the law." See Professor A.V. Dicey's Introduction to the Study of Law of the Constitution, 10th edition, Macmillan Education Limited. The end of quote. The rule of law thus denotes absolute supremacy or predominance of law. It is a concept that goes hand in hand with other concepts such as good governance and democracy. Democracy is therefore naturally anchored on the rule of law. In the words of Samson Odemike Wifo, GSC retired, in the Attorney General of the Federation and Guardian Newspapers Limited and others, said, in order for the judiciary to perform its allocated functions under the Constitution effectively and satisfactorily, it must be purposive in upholding the rule of law. It is its sacred responsibility to do so. It is antithetical to the idea and practice of the rule of law for anyone to render the judiciary ineffective through any subterfuge or by sheer exercise of absolute authority or by interim posturing. It is even more so when a glittering facade of judicial independence is presented upon such identified ground norm, only to seek to protect every governmental action by asta clause. We should be able to say, and I do say, that it is not good for a country such as Nigeria, end of quote. Legal framework. The concept of judicial independence and the need to safeguard it has always attracted and found its way into many international and national legal instruments. Therefore, presently, the imperative of judicial independence has long gained international and national traction. A look at some of these relevant instruments is therefore germane at this point. International legal instruments, as early as December 1948, the United Nations adopted the Universal Declaration of Human Rights. Article 10 thereof provides that, and I quote, everyone is entitled to full equality, to a fair and public hearing in an independent and impartial tribunal, in the determination of his rights and obligations, and of any criminal charge against him, underline supplied for emphasis. In addition to the above, in 1985, the United Nations General Assembly endorsed the basic principles on the independence of the judiciary, which was either adopted by the which was earlier adopted by the 7th United Nations General Congress on the prevention of the crime and treatment of offenders on 6th of September 1985. Similar provisions can be found in the following international legal instruments. A. International Covenant on Civil and Political Rights, ICCP, also adopted by the United Nations General Assembly Resolution 2200A on the 16th December 1966 and effective from 23rd March 1976 in line with Article 49 of the Covenant. And B. The African Charter on Human and People's Rights, 1981. The above declarations have found their way into the Constitution in many countries where similar provisions are enshrined, Nigeria inclusive. Let us take a brief insight into some aspects of judicial independence as contained in the Constitution of the Federal Republic of Nigeria, 1999. Let's look at the constitutional safeguards aimed at ensuring the independence of the judiciary. Nigeria's legal framework provides a robust foundation for judicial independence, anchored primarily on the 1999 Constitution of the Federal Republic of Nigeria, as amended. The Constitution contains several provisions aimed at protecting the independence of the judiciary in Nigeria. Some of these include the following. A. Separation of powers. The independence of the judiciary goes hand in hand with the doctrine of separation of powers. In this regard, sections 4, 5, and 6 of the 1999 Constitution clearly spell out and delineate the powers of the legislature, executive, and judiciary as separate arms of government. In doing so, it sought to establish and institutionalize a robust system of checks and balances that is clearly designed to prevent the concentration of power as well as protect judicial autonomy. This principle has long been upheld in a plethora of judicial decisions, one of which is the Attorney General of the Federation and Guardian Newspapers Limited, where my Lord, Karibi White, GSC retired, held at page 71 in paragraphs A to C that, quote, a notable feature of the amended Constitution is the distribution of the exercise of governmental function among the three principal and separate departments of the legislature, the executive, and the judiciary. The Constitution also prescribed the scope and limits for each department, and that within its jurisdiction, the exercise of power is supreme. Accordingly, implicit in the powers so vested, the one was not to interfere in the exercise of the powers of the other, except to the extent to which the Constitution confers such power of interference. Similarly, in Attorney General Abia State and others against the Attorney General of Federation, the Apex Court also held that, and I quote, the principle behind the concept of separation of powers is that none of the three arms of government under the Constitution should encroach into the powers of the other. Each arm, the executive, legislative, and judicial, is separate, equal, and of coordinate department, and no arm can constitutionally take over the functions clearly assigned to the other. Thus, the powers and functions constitutionally entrusted to each arm cannot be encroached upon by the other. The doctrine is to promote efficiency in governance by precluding the exercise of arbitrary power by all the arms and thus prevent friction. End of quote. On whether the executive can usurp the powers of the judiciary and vice versa, Ugubi GSC in Goyang, Kayili, and LC Yilbok, and others, also stated, and I quote, the Constitution is very clear and specific on separation of the powers between the arms of government, to wit, the executive, legislature, and the judiciary at both federal and state levels. Thus, the executive cannot exercise or usurp the powers of the judiciary, and vice versa, end of quote. Appointments, promotion, discipline, and security of tenure of judges. by the provisions of sections 256, 271, 276, and 291 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, judges hold security of tenure until a mandatory retirement age of 70 and can only be removed through a rigorous process upon the recommendation of the National Judicial Council. These provisions protect them from arbitrary removal by the executive. In relation to the foregoing, as has already been alluded to, the National Judicial Council, established by Section 153 sub 1 of the Constitution and paragraph 21 of the third schedule to the Constitution, is responsible for the appointment, promotion, discipline, and removal of judicial officers. Its composition, primarily of judicial officers, is intended to safeguard judicial independence from political interference in these critical areas. The nature and scope of the powers of the National Judicial Council, especially in relation to discipline and removal of judges, have often come under judicial consideration and determination. For instance, in Gajiwa and the Federal Republic of Nigeria, the Court of Appeal held that a serving judicial officer cannot be subjected to a criminal prosecution without complying with the condition precedent for subjecting such judicial officer to the disciplinary jurisdiction of the National Judicial Council. According to the court, the aim of this is not to shield any judicial officer, but to ensure that there is a ground to proceed against such person before their prosecution. This is also to ensure that there is no abuse by these agencies of the executive. Arising from the above decision, therefore, whenever a breach of judicial oath occurs, it is a misconduct itself, and the lot is on the National Judicial Council as the appropriate body to investigate such breaches by the judicial officer, and if found to be so, such judicial officer shall face disciplinary action. This may take the form of a recommendation by the National Judicial Council to the appropriate authority, which is either the President, in the case of a federal judicial officer, or the governor of a state, in the case of a state judicial officer, for the removal of such judicial officer. It is after this is done and accepted by the appropriate authority in compliance with the provisions of the Constitution that the relevant law enforcement agents or agency is at liberty to make the said judicial officer face the wrath of the law. Any act done by the law enforcement agent or agency in violation of the above is tantamount to denying the agency its powers to discipline judges. Must, however, be noted that if a judicial officer commits theft, fraud, murder, or manslaughter, arson, or the likes, which are crimes committed outside the scope of the performance of his official functions, he may be arrested, interrogated, and prosecuted accordingly by the state directly without recourse to the NJC. These classes of criminal acts are not envisaged and captured by the provisions of paragraph 21, part 1 of the third schedule. Section 158 of the Constitution also clearly spells out the independence of the National Judicial Council by providing that in exercising its powers or power to make or to exercise disciplinary control over persons, the National Judicial Council shall not be subject to the direction or control of any other authority or person. Financial autonomy. This is another catchment attraction that is pivotal to judicial independence, which is provided for under Section 81, sub 3, and Section 121, sub 3 of the 1999 Constitution. In this respect, the Constitution provides that all amounts standing to the credit of the judiciary are charged directly on the Consolidated Revenue Fund of the Federation and the states, and shall be paid directly to the NJC or at the level of the states to the various heads of court. This is designed to prevent financial leverage from being used against the judiciary. Under various constitutional provisions, the remuneration, salaries, and allowances of state judicial officers are charged upon the Consolidated Revenue Fund of the Federation and are paid directly to the National Judicial Council for disbursement to the heads of the courts established for the states under Section 6 of the Constitution. And the condition of service, remuneration, and allowances payable to the state judicial officers cannot be altered to their disadvantage after their appointment. The appointment process. The appointment process of judges of superior courts is as provided under sections 231, 238, 250, 254A, 256, 261, 266, 271, 276, and 281 of the 1999 Constitution. While at various states, appointment of judges of lower courts are as contained in the respective laws establishing the other cadre of courts. In relation to superior courts, judicial appointments are made by the president or governor on the recommendation of the National Judicial Council. The National Judicial Council, headed by the Chief Justice of Nigeria, plays a critical role in vetting and recommending candidates, theoretically insulating the process from undue political influence. To guide the National Judicial Council in this process, the National Judicial Policy 2016 recognizes, and I quote, that a transparent and carefully designed appointment process is indispensable to an efficient and independent judiciary that is able to command public confidence in the administration of justice and capable of promoting and protecting the rule of law and human rights. Immunity. Judges enjoy a degree of immunity from civil and criminal proceedings for actions taken in the performance of their judicial duties, allowing them to make decisions without fear of personal litigation, which goes to foster judicial independence. On the role of the Nigerian judiciary in the sustenance of democracy and the rule of law, this paper, the point must be immediately understood or underscored that the prime role of an independent judiciary in the sustenance and promotion of the rule of law in Nigeria is, in the words of Shakespeare's Julius Caesar, quote, as constant as the northern stars, of whose true fixed and resting quality there is no fellow in the firmament, end of quote. In this regard, it is today expedient to reiterate the fundamental axiom that an independent and courageous judiciary is the greatest asset of a free people anywhere in the world. This is absolutely so, because by the very nature of its constitutional mandate, the judiciary is the citizens' last bastion or line of defense and hope in a free democratic society. Indeed, that is the line separating constitutionalism from totalitarianism. The role of the judiciary cannot be overemphasized, as it is a stabilizer in the political system and has the extra duty of the protection of the Constitution and acts as a check on the various political actors and the democratic theater, The judiciary is an indispensable organ that balances the exercise of powers in the polity of any nation. It resolves conflicts involving individuals, organizations, government, and political parties. It is therefore a truism that an independent and impartial judiciary holds a central place in the democratic scheme of things, thereby strengthening the pillars upon which our democracy rests. In an age where public perception has become screwed against the judiciary, a judge, through his judgments, must exemplify independence of thought, tempered only by the boundaries of justice, the letters and spirit of the law, and passionate pursuit of the rule of law at all times. This point has been aptly reiterated by the Apex Court in a truckload of judicial decisions. One of such cases that readily comes to mind is that of Governor of Lagos State, Ojukwu, where Obaseki GSC of blessed memory famously stated that, and I quote, I think it was the legendary philosopher Cicero who, about 2,000 years ago, echoed, quote, amid the clash of arms, the law is silent. However, barely 70 years ago, Lord Atkin, that quintessential courageous, erudite common law jurist, thought otherwise, and cherishingly echoed the ever-immutable dictum. In this country, that's England, amid the clash of arms, the laws are not silent. They speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which, on recent authority, we are now fighting, that the judges are no respecter of persons and stand between the subject and any attempted encroachment on his liberty by the executive, allowed to see that any coercive action is justified by law. See Siege and Anderson. Citation is 1942, Appeal Cases, page 206, by Lord Atkins at page 244. In our present circumstances, I dare say that as it was in England in the days of Lord Atkins during the Second World War, so it must be in Nigeria today, given that wherever it finds itself and whenever, the law speaks the same language. From the above, two things are often lost to the undiscerning mind, but which I must again emphasize here today are as follows. Firstly, the above very courageous dictum of Lord Atkins in the House of Lords decision in Siege and Anderson's case supra was actually a dissenting opinion of His Lordship, which went on not just to attain global acclaim, but has also firmly planted the feet of the erudite Lord Atkins in the sands of time. Little wonder that not too many people today remember other eminent justices who gave concurring decisions in favor of the continued denial of the right to personal liberty of Mr. Robert Liversidge and his continued detention by the executive at that time. Secondly, the Ojukwu case, which I have just referred to above, actually arose in a military dispensation when basic rights of Nigerians were usually emasculated by military decrees, pursuant to which military governors and others sought to unlawfully evict Chief Emeka Ojukwu and family from his house at number 29, Queen's Drive, Ikoyi. Yet, even in such situations, in the midst of military might and arms, our courageous judges shone brightly in once again underscoring the point that the law is no respecter of persons by making sure that the Nigerian judiciary stood firmly between the subject and a clear encroachment on citizens' right to property by the military. Also, in this regard, Basaki GSC of blessed memory further stated succinctly that, quote, the Nigerian Constitution is founded on the rule of law, the primary meaning of which is that everything must be done according to law. More relevant to the case in hand, the rule of law means the disputes as to the legality of acts of government are to be decided by judges who are wholly independent of the executive. The judiciary cannot shirk its sacred responsibility to the nation to maintain the rule of law. It is both in the interest of the government and all persons in Nigeria. The law should be even-handed between the government and citizens. End of quote. I can only add that history will be unkind to those who fail in the performance of this sacred duty. Out of respect for brevity, permit me to briefly highlight several other areas in which an independent Nigerian judiciary has helped to uphold and strengthen our democracy. They include resolution of various and often contentious pre-election and post-election petitions. B, inter-party and intra-party disputes. C, local government autonomy. D, review of impeachment of political office holders. E, resolution of disputes between the federal government and states, and as between states over resource control. And F, resolution of disputes between various arms of government, etc. Go on now to challenges to judicial independence. Despite constitutional safeguards, some of which have already been highlighted above, independence of the judiciary in Nigeria has continued to face many daunting challenges. Some of these include the following: financial dependence on state judiciaries. This stems from the fact that while the Constitution mandates financial autonomy for the judiciary, its practical implementation, especially at the level of the federating units or states, remains a mirage. As we speak, many state judiciaries still rely on the executive for funds for everything, thereby hindering their ability to carry out basic operations, provide facilities, and even pay staff salaries. While it must be considered that here in Edo State, we have made significant progress in this area, for which we commend the Edo State government, not too many states around the country are this fortunate. What we find is that in many of such states, the judiciary still go cap in hand, virtually on a daily basis, to appeal and source for funds. The success or otherwise of these daily pilgrimages to the executive is often determined by the benevolence of the incumbent governor. We may recall that in the ensuring and persistent national fight to implement and enthrone the constitutionally guaranteed financial autonomy for the judiciary, there has been several industrial and court actions by the Judiciary Staff Union of Nigeria, JUSUN, which has largely left the union scarred and battle-weary due to stiff resistance or pushbacks from some state executives. Budgetary allocations. Akin to the point that has just been made is the fact that even where funds are directly charged, the adequacy of budgetary allocation and release of funds by the executive remains a concern, adversely impacting infrastructure development, training, and welfare of judicial officers and the judiciary. Social media challenge. This digital age has come with plenty of benefits, some of which have radically changed the way adjudication was conducted in the past. For instance, we now have virtual hearing of cases, electronic filing of court processes, electronic service, and even provisions for digital recording of court proceedings, etc. All of these are now contained in various rules of court. In the labyrinth of these loads of positives, we, however, now also have many situations where, due to blatant abuse of various social media platforms, the independence of the judiciary is gradually being threatened or eroded. One of such encroachments is the existence of an almost parallel judiciary in the social media space with unknown or unofficial and extrajudicial courts. In these largely unregulated courts, the actors, under the guise of content creation, constitute themselves into prosecutors, lawyers, judges, and executioners over matters, some of which are still pending or anticipated in court. In doing so, they regularly subject potential or pending cases to social media trials and unfair commentaries, even when they know little or nothing about the facts and circumstances of the cases or issues devoid of evidence. While it is true that our courts are not courts of public opinions, justice is rooted in public confidence and the perception of the proverbial reasonable man. In this sense, therefore, while judges are obliged to ignore the outlandish views expressed extrajudicially on social media, the problem, however, is that these contents are believed by unsuspecting members of the public without questioning the veracity and motives of such publications. When such cases eventually find their way to court and the judges, after a careful evaluation of available evidence and the law, holds contrary to the verdict of social media pundits, such situations can only go to feed unsubstantiated negative perception of the judiciary and spurious allegations of corruption or improper conduct. This undoubtedly constitutes very active threat against the independence of the judiciary in Nigeria. Political interference. This serious threat to judicial independence may take the form of direct or indirect meddling in the performance of judicial functions, screwed appointments, processes, poor funding, or resistance by some state executives to the grant of financial autonomy to the judiciary of those states. I was going to say not Edo, but the minority leader is here. I don't know if I can say that. There have even been recent reports of attempts by some state governors to unlawfully remove some heads of court in their states from office without recourse to the NJC. All of these only strike at the heart of our collective quest for judicial independence. In respect of this, in the case of Honorable Justice Raliat Elelu Habib and another, and the Honorable Attorney General of the Federation and others, on the 30th day of April 2009, the Governor of Kwara State, as head of the executive, forwarded an address to the House of Assembly in which the Governor concluded that the appellant, that's the head of the judiciary in Kwara State, be removed from the office of the Chief Judge of Kwara State for inability to discharge the functions of her office, and that her act of misconduct stated above also contravened the code of conduct for chief judicial officer of the state. The House of Assembly summoned, ordered, and directed the appellant to appear at its plenary as part of the process of its exercise of disciplinary control over her. The appellant instituted an action at the Federal High Court where she asked the court to interpret the provisions of the Constitution, particularly sections 6, 153 sub 1, and paragraph 21D of the third schedule to the Constitution of the Federal Republic of Nigeria 1999, and determine whether the Governor and the House of Assembly can exercise or constitutionally exercise disciplinary control over her without the input of the National Judicial Council, the body exclusively empowered under the Constitution to exercise disciplinary control over judicial officers, including the Chief Judge. The Federal High Court dismissed all the objections on jurisdiction and granted all the claims of the appellant. The appellants appealed to the Court of Appeal. The learned justices, with a majority of 4-1, came to the conclusion that the Federal High Court lacked the jurisdiction to adjudicate on the matter. Both parties appealed and cross-appealed to the Supreme Court. The Supreme Court held that, having regard to the relevant provisions of the 1999 Constitution, the Governor of Kwara State and the House of Assembly of the state cannot remove the Chief Judge of Kwara State from office without recourse to the participation of the National Judicial Council in the exercise. Therefore, the Governor of Kwara State and the House of Assembly of Kwara State acted outside their powers, since they arrogated unto themselves the powers of the National Judicial Council, which they had no authority to do. When the Constitution has stated steps that must be taken before an action can proceed, then omitting to do so will render such an act one made in futility. The Governor of a state must await the recommendation of the National Judicial Council before proceeding to act with the State Assembly on the removal of a judicial officer, including the Chief Judge. Corruption. Corruption is a global phenomenon that cuts across all institutions. Like every other body, there are pockets of bad eggs here and there. The judiciary is not an exception. Recently, former President Olusegun Obasanjo, in his new book, Nigeria, Past and Future, publicly alleged that the judicial system has become a court of corruption rather than a court of justice. He warned that justice in this country has become commodified with despair, anarchy, and violence replacing justice, order, and hope. Unquote. Clearly alarmist and overgeneralized as these statements or these remarks might be, the point that must be underscored is that a corrupt judge is a grave source of worry for all lovers of justice and judicial independence. In the word of Justice Muhammad Weiss, former Chief Justice of Nigeria, quote, "A corrupt judge is more harmful to society than a man who runs amok with a dagger in a crowded street." The latter can be restrained physically, but a corrupt judge deliberately destroys the moral foundation of society and causes incalculable distress to individuals through abusing his office while still being referred to as honorable, unquote. The hydra-headed monster of corruption is one that goes beyond illicit exchange of money. As I have said in numerous other fora, the scourge of corruption extends to and also includes a clear semblance of corruption. Therefore, corruption like bias may be actual or apparent. It is actual where the judge has direct pecuniary or other interest in the outcome of the litigation, whereas it is apparent where there is a semblance of it. In either case, a judge cannot reasonably lay any claim to judicial independence. It is a self-inflicted impediment to his liberty to act judicially and judiciously. Nigerian judiciary has not denied the existence of corruption within its ranks. Rather, it has continued to fight the scourge within its enclave with all its might. Paragraph 6 of the National Judicial Policy of the NJC, earlier referred to, clearly states that, quote, the Nigerian Judicial Policy recognizes that the greatest and most damaging challenge to administration of justice is corruption, and that tackling this challenge must go beyond mere exhortation and sentiments. To this end, several judicial officers have been dismissed from office on proven cases of corruption by the National Judicial Council and the various judicial service commissions at the state level. Conclusions and recommendations. This paper has dealt with judicial independence, democracy, and rule of law in Nigeria. In doing so, through the prism of relevant provisions of the 1999 Constitution and the law, as well as some decided cases, a critical look has been given to this all-important topic, especially in the areas of the legal framework and pathway for the attainment of the much-desired judicial independence, various aspects of this subject matter, the challenges, and so on. From this discourse, it is clear that for there to be real independence of the Nigerian judiciary, it is recommended that the constitutional provisions of financial autonomy for the judiciary must be fully implemented in all states of the Federation. In doing so, adequate budgetary allocations must be provided by the executive aimed at ensuring that the judiciary as an institution is well funded. The process of appointment and promotion of judges must also be reformed to ensure that political interference in the process is eliminated. We must be mindful of the fact that the power of the judiciary lies in the confidence our people have in its activities and decisions, which every judge must protect. To this end, it is recommended that there has to be more serious concerted efforts to enforce the provisions of the Cyber Crimes Act 2015 with a view to discouraging unwarranted wanton publications in our digital media space that are clearly aimed at maligning or prejudicing the exercise of judicial independence in adjudication. No matter the personal view held by all of us on this subject matter, one thing that is crystal clear is that if you do not want an independent judiciary today because you are in power, a day will certainly come when you will earnestly crave for judicial independence, having now found yourself on the other side of the power or out of office. I thank you all for your patient listening. God bless.
Please, another round of applause for the Honorable Chief Judge of Edo State. Thank you, my Lord, for that insightful lecture. Thank you. I'm sure you agree with me that my Lord has opened our eyes to the issue of judicial independence and the rule of law, particularly the role of the judiciary. We on the other side, we only criticize, and we have coined out a term, judicial corruption. But my Lord has opened our eyes to the role that the NJC and indeed judges have been playing in fighting corruption. Please, once again, a round of applause for the Chief Judge of Edo State. My Lord, thank you so much for that lecture. At this time, we are going to acknowledge our professors who are here with us. But just before then, yes, I knew I saw a distinguished senior advocate earlier on. Yes, that is Mr. Ken Mosier, senior advocate of Nigeria. You're welcome, sir. You're welcome, sir. Yes, at this time I would like to recognize our professors. They are known to my Lord. In the next 10 minutes, we'll be out of here. Okay, thank you. Thank you. Earlier on, I mentioned that we were expecting the representative of the Idigbe family. I'm happy that an alumnus of this university, okay, I'm seeing him. Okay, you are there. All right. He's here. We are going to bring you up to the high table. You are going to come up here to sit. We are not going to ask you to make any speech, but you are going to come up here to sit. We know the Idigbe family always sends a representative whenever we have the Idigbe Memorial Lecture. Please join me in welcoming Mr. Oyeka Ehwogo. Yes, please come up. Mr. Oyeka, you're welcome. You're welcome. Vice Chancellor, sir, this is the representative of the Idigbe family. It's Mr. Oyeka Ehwogo. He graduated from the Faculty of Law. At least I know that very well. You're welcome. All right. I would like to recognize the I know now. I know Mr. Pius Ohiwo is the husband of my classmates. Yes, I know. You're my personal person, so I must recognize you. The former chairman of NBA Benin, Mr. Pius Ohiwo, you are welcome. The NBA vice chairman, Mrs. Itoha Rama, you are welcome. The chairman of NBA. Oh, I'm sorry. That was a mix-up. I'm just saying you. Don't worry. Our colleague will discipline me when I get back to the faculty. I'm referring to your wife. But please pardon me. You are welcome. Thank you very much, sir. Okay, at this time, I would like to recognize our professors. Student, please, you join me in recognizing the former Dean of the Faculty of Law, Professor Nathaniel Idigbe. You're welcome, sir. This fan, sir, what I want to say now, it is this fan that caused it. This fan just caused problem. And I don't know why the fan is here. Because how would I have committed that iniquity? The proper thing is to recognize first the former Dean of Law, Professor Richard Idubo, PhD. You see where I said this fan, this standing fan, how many strokes of cane for this fan? Oh, zero. Oh, thank you, sir. You're welcome, sir. All right, please join me in welcoming Professor Ipomosa Omori, former Dean of Law and former Deputy Vice Chancellor, Administration. Please join me in welcoming Professor Mrs. Obehi Odiase Alejimelen. You're welcome, ma'am. Please join me in welcoming Professor Mrs. Victoria Onuoha. Another former dean of the Faculty of Law is here. She is Professor Mrs. Violet Aigbo. Thank you. Thank you. We also have with us here Professor Job Odion. You're welcome, sir. Professor Matthew Olong. I saw him earlier. Oh, you see, it is the fan that is causing problem. Thank you. You're welcome, sir. Also with us is Professor Eric Okoji. You're welcome, sir. And for all you've done to see that today's event is successful, thank you very much, sir. Thank you, sir. Another round of applause for him again. Please join me in welcoming Professor Mrs. Ngozi Unuigbe. Also here is Professor Nelson Ojukwoba. You're welcome, sir. We have with us Professor Dennis Odige. You're welcome, sir. Please, at this time, I think I'm unable to follow the order. I'm seeing Professor Osaitin Aibobo. You're welcome, sir. Yes, the fan will not cause another problem again. Join me in welcoming Professor Mrs. Eunice Eragbe. At this time, I must mention her husband, who is here with us too. Welcome, Professor Eddie Eragbe, former university orator. Is that how you welcome my boss? You're welcome, sir. Please welcome. I thought I saw Mrs. Ezekiel, Professor Mrs. Ezekiel here. Yeah. Professor Mrs. Bobolaji Ezekiel. You're welcome, ma'am. Professor Anthony Osaro Ewe, you're welcome. University PRO was here earlier on, Dr. Mrs. Benedicta Ehanire. I know she was here. You're welcome, ma'am. We have the lecturers of law. There are many, but the vice chancellor is busy, and then the CJ is very busy, so we are not going to keep them here. Please, my colleagues, you all are. Professor Michael Atta, you're welcome, sir. My colleagues, you are welcome. Welcome all your lecturers. Vice Chancellor, sir, before we leave, the spirit is prompting me to acknowledge one person, even though he's not a professor. Don't tell me which spirit. It's a good spirit. Please, welcome Mr. David Aigbeka. The spirit that prompted me is a good spirit. It's a good, some of you know why. It's a good spirit. You're welcome. At this time, we're going to have the vote of thanks. The vote of thanks is going to come, okay? And the vote of thanks is going to be taken by a distinguished scholar in the Faculty of Law. She's a woman that we all respect. Okay, just before I call you, okay, among the judges, I'm sorry, Vice Chancellor, sir, Professor Emeka Chiano is here. I'm just... Professor Chiano, you are welcome. I'm sorry, I didn't see you at all. I'm sorry, you're welcome, sir. Thank you very much, sir. Okay, Mr. Chris Otasowe. Okay, I thought you have been elevated. All right, you are the secretary of the NBA. That's the one I know, but when they were saying chairman, so I was wondering when. You are welcome. Thank you very much. Okay, at this time, we are going to take, yes, after the vote of thanks, we still have announcements. There is an important announcement we are going to make after the vote of thanks. I'm keeping Professor Idigbe standing. That is wrong. She's going to give us the vote of thanks. You're welcome.
Good afternoon, everybody. Vice Chancellor, the Chief Judge of Edo State, distinguished guests, students, everyone present, good afternoon. It's a privilege for me to deliver the vote of thanks on behalf of my Dean and the Dean of the Faculty of Law and the entire Faculty of Law. The close of this remarkable 20th Idigbe Memorial Lecture. First, we want to express our profound gratitude to our Vice Chancellor for his leadership, his presence, and unwavering support for intellectual engagement and the advancement of legal scholarship within our university and outside. Sir, your commitment actually continues to provide the enabling environment for occasions such as this. Thank you very much, sir. To our distinguished guest lecturer, the Chief Judge of Edo State, we say a most sincere thank you, sir. Thank you very much, sir. Your lecture was very rich. It was illuminating and deeply thought-provoking. You have not only honored the enduring legacy of Idigbe, but have also challenged us to reflect critically and recommit ourselves to excellence, integrity, and service, especially integrity. We are truly grateful for this time, insights, and depth you brought to this platform. We respectfully also acknowledge and deeply appreciate the presence of representative of the Idigbe family. Welcome, and thank you. Your attendance gives this memorial lecture its true meaning and continuity. Thank you for preserving and sharing in this legacy and for allowing us year after year to celebrate and reflect on the values that Justice Idigbe embodied. Thank you. Okay, and quickly, we also want to thank our professors, our lecturers. We thank you very much for sustaining this important intellectual tradition and for your continued membership of generations of legal scholars. And to our dear Faculty of Law students. Your presence and attentiveness today affirm that the future of the legal profession is in capable hands. May the insights shared here inspire your academic and professional journeys. We also want to express sincere appreciation to members of the bar, invited guests, especially our senior advocates of Nigeria, our most respected judges, guests, friends of the faculty, and all well-wishers who have graced this occasion. Your presence has added dignity and distinction to this event. Finally, we commend the organizing committee, we cannot forget them, and all those who have worked assiduously behind the scenes to ensure that the seamless success of today's lecture was a reality. Your dedication and hard work are truly, truly appreciated. So on behalf of the faculty and organizing committee, I want to again say thank you all for making the 20th Idigbe Memorial Lecture an impactful occasion. May the legacy we honor today continue to inspire scholarship, integrity, and service in the legal profession and beyond. Thank you all, and God bless you.
Thank you. Thank you, Professor Idigbe. I know you always do it well. Thank you very much. Thank you. Another round of applause for her. We have friends of the faculty here, the Faculty of Law. We thank you so much for coming and would like to recognize you. And they came very early. Professor Festus Imoetinye, you're welcome, sir. You're welcome. Thank you for coming. The former chairman of ASU Uniben branch, Professor K.O. Ilevare, you're welcome, sir. Thank you for coming. Thank you, sir. We have an important announcement here. After the announcement, we'll have the Uniben anthem and the pledge only, not the national anthem. Uniben anthem and then the pledge. And after that, we'll rise while the Vice Chancellor and the Chief Judge will take their exit. Vice Chancellor, sir, going to be this way? Okay. The Vice Chancellor and the Chief Judge, so that we'll exchange pleasantries with his fellow senior advocates and so on. The announcement is that after now, there will be a cocktail at the Faculty of Law for our guest in honor of our guest lecturer, the Honorable Chief Judge of Edo State. And all the judges are expected at the cocktail. The learned silks are also expected at the cocktail. And then members of the bar, please. Of course, that includes all the professors and all lecturers. So members of the bar are also expected at the cocktail after now. Thank you very much. We are now going to, and then Professor Ilevare, Professor Imoetinye, please, you are also invited to the cocktail. Thank you very much, sirs. Yes, the minority leader is expected at the cocktail. Thank you very much. Okay, we are going to rise now for the Uniben anthem, and thereafter we'll take the pledge. Okay, at the count 2, 1, 2. The wide, wide world, our fruitful works unfold. We sowed with joy and pride, we good our common goal. And voice for all, we arise, mighty Uniben, roll and go, clap in your fertile green land, knowledge for service untold. The pledge. Free to be faithful, loyal, and honest, to serve Nigeria with all my strength, to defend her unity, and uphold and honor. So help me God. Thank you. We remain standing while the Vice Chancellor and the Chief Judge. Thank you, sir.